registered was against a street vendor for vending. So for actually vending, there was an FIR registered. So I think the and that is something that is actually protected under the Street Vendors Act. They have the right to vend. They have the right against police action, and police is actually prohibited from taking action against them. But the very fact that that was the first FIR that was registered, I think in some way shows the way in which these laws would be used. If you remember, one of the first larger protests that took place against this, other than civil society organizations, were the protests by truck drivers. And the reasons that one of the reasons that they were saying is that the law, the IPC previously, the punishment for death by rash and negligent act was, I think, if I'm not wrong, 3 years or a little lesser.
2 years.
2 years, and subsequent, and by this law it has been increased. So I think up to 10 years, if I'm not wrong.
So the hit and run provision.
Exactly, this is a hit and run provision, and they have penalized the act of going away from after hitting, the running part of it, basically the person going away. And they say that the reason that many of them go away is because if they're there, they get beaten up by people that come together, crowds that come together. So one of the first protests against it was actually by the truck drivers. So the full extent of of how dangerous these laws are on marginalized communities is something that we still have to be seen. But the fact of the matter is, even as we stand today, the law is obviously disproportionately used, or it's used in a manner that will affect people from marginalized community, whether it's Dalits or Adivasis, much of or the working class or religious minorities like Muslims, in a much more graver fashion. So if you look at the prison data, I think one of three or two of three people of under trial prisoners belong to the Dalit and Dalit, Adivasi or OBC communities. So you have the way in which itself it anyway takes place. Like Kanabiran famously said, the law defines the offence, the state defines the offender. So who is going to be the criminal? Whether it's going to be Ambani for not doing something that he ought to have done, or not in a case of cheating or something, or whether it's going to be someone like the street vendor, that is going to be determined by the state. So you anyway you don't have a level playing field in this. So when you're on that, you've given arbitrary powers to the police to take this form of action. Who is it going to affect the most? Then the people that is going to be affected the most are people from from marginalized communities. For example, now if you think about registering an FIR, if you have say so the decision to register or not to register an FIR for the police, there is going to be so much to be said about who the accused is and who the person who's giving the complaint is. So if you have, for example, a worker giving a complaint against management for some kind of assault, the chances are they're not going to register an FIR, and they're going to say this is there against you. And on the contrary, if you have, say for example, an FIR that is being a complaint that is being given by a dominant caste person against a person belonging to the Dalit community, the chances are that FIR will actually get registered, because all this is going to come into is going to become a consideration. So I think the fact that you have given this kind of arbitrary powers to the police itself is something that is something that's very that is going to disproportionately affect people from marginalized communities. The other thing is, of course, that some of the offences that have actually been brought in, I mean, maybe there will be another, I mean, we'll speak about dissent, but the fact is that dissent is actually, who are the people who are going to be dissenting, who are the people who are going to be protesting? It is people from marginalized communities. So they have criminalized hunger strikes, something that, I mean, it's really ironic that in our country they should be criminalizing hunger strikes, but they have criminalized hunger strikes. The offense in which this new sedition, which is not called sedition, the way in which it is in which it is actually worded, it's so vague. In fact, it says it excites or attempts to excite subversive activities. What does subversive activities mean? Right? The offense of terrorism, of the offense of terrorist act, includes any action by any bombs, whatever, by any other means likely to cause loss or damage to destruction of property. So that's affecting people who are most vulnerable through these means. I mean, I'm sure if you look more, there's a lot more to that we have not maybe uncovered. But yeah,
encourages feelings of separatist activity. So somebody feels.
I think if you could just continue answering in terms of what is some of your understanding of whether there is a criminalization of dissent, whether there is a criminalization of freedom of speech and expression that is not favorable to the government today by these new laws, and if so, how is it exactly doing that?
I think this provision, I think is worth reading because
Yeah.
uh, 152, which says whoever purposely, right? So the term purposely is not used in criminal law. Right? We say voluntarily, intentionally, thing, but not purposely, which is like a general day-to-day use term. So there's no interpretation of that. So whoever purposely or knowingly, by words either spoken or written, or by signs of a visible representation, or by electronic communication, or by use of financial means or otherwise, excites or attempts to excite secession or armed rebellion, or subversive activities, or encourages feelings of separatist activities, or endangers sovereignty or unity and integrity of India, or indulges in or commits any such act shall be punished with imprisonment for life.
For life.
Right? Or which may extend to 7 years. So life is the. So what does it even mean? Right? So what we're talking today might encourage one person here to have feelings of separatist activity. And if you've done it purposely, then it becomes this offense. So like I was saying, under the sedition 124A, you had you had a particular understanding, right, with Supreme Court judgments that had set it. Now with this, it becomes open again. Going back to this organized crime provision, and that's the other. So also there's in theft, there's now an offense of snatching. Snatching is literally snatching somebody's purse. I think, and that's again one of those things that to help women because there's this chain snatching, bag snatching, etc. But there was a state amendment, if I'm not wrong, in Punjab. So one state had it, Haryana, I think Haryana or Punjab had it. So the reason why what one state had done has come across the country is, but so the organized crime thing says, the definition says, any continuing unlawful activity, including kidnapping, robbery, then it becomes interesting, vehicle theft, uh, extortion, land grabbing, contract killing, economic offense, cyber crime, trafficking of persons, drugs, weapons, illicit goods or services, human trafficking for prostitution or ransom, is a set of offenses, right? So, who are the people that you've been arresting for offenses? You don't have, not that they should add more offenses to this, but you don't have other sets of offenses which you could consider people who are not poor committing, right? So you've listed some of those, and then says that acting in concert singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by using violence, threat of violence, intimidation, coercion, or any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute organized crime. So it's a wide definition. And then when you go to another offense called petty organized crime, the next one, it says whoever being a member of a group or a gang, either singly or jointly, commits an act of theft, snatching, cheating, unauthorized selling of tickets. Okay, so black market trading, unauthorized betting or gambling, selling of public examination question papers, or other similar criminal act is committing petty organized crime. So again, in that your the imprisonment here is minimum of 1 year, maximum of 7 years. So again, have been protesting this section 106 because it says now that this offense of causing death by negligence is punishable with imprisonment for 5 years. But if that act is done by a registered medical practitioner while performing a medical procedure, then the maximum punishment is 2 years. And if it's a truck driver who run away from the scene, that is 10 years. It's of course they have not notified 1062, which is the truck driver provision, because they protested against it. That's on hold. But the IMA has been arguing that because the Supreme Court had said that negligence has to be interpreted as gross negligence, doctors were really practically not covered under the previous provision. Now you brought them back in and covered them with 2 years imprisonment. And again, what they have been telling doctors is, see, we have reduced punishment, but no, they have criminalized it back again. So So you see all of these ways in which, again, how do you define an economic offense, right? Economic offense. No, we may think of Malya or Nirav Modi, etc. But economic offenses from theft to cheating to things that may involve 10 rupees, right? So it can be used in both sort of ways. So I think just again going back to what we said earlier, it's also how the police would interpret some of these provisions that will actually uh, uh, sort of define the ways in which this law will head in the next few years.
So what I'm hearing also a lot is that the police now has arbitrary powers. It is also almost at a very instance of an offence, deciding whether prima facie that's an offence itself and the proper offence is made out, which is essentially a judge's job. It is a judge's responsibility to be able to assess whether a prima facie crime has been done or not done, right? It is not the application of mind of the police, which we know are biased entities in that sense. So, in your understanding, are you seeing this almost as a transition to some form of a police state that we are reaching to? And one is that question, maybe one of you can take. And the other question that's really coming to me is that the offense of terror acts, right? The offense of terror acts essentially now has been included under the heading of offenses against human body, right? And why have they done that? So those of you who are non-lawyers here, so the offenses that are like terror acts or like sedition, or even for that matter hate speech offenses, right? All of them are offenses against the state as per the CRPC, and otherwise understood as against the state because they're against the public at large, they're against society at large. So what is really the intention of looking at these terror acts provisions as an offense against human body vis-a-vis how we have understood it under UAPA or previously under TADA and so on? That's one question. And the other question, of course, is in terms of the other question, like I already asked, if one of you can just take one each.
So I think the one other thing that you see is not only about the police. I'm trying to find the provision. It's about also the prosecutors, because you have now a district level, so directorate of prosecution, not only a state level directorate of prosecution. And if I remember correctly, it says somewhere that all charge sheets will go to prosecutors. So therefore, which is not something which, rightly or wrongly, there was a separation saying the police will handle anything and prosecutors are supposed to be independent, the officers of the court. So they are not going to advise on what the charge sheet should have, etc. So I wouldn't say it's only the police. I think the state is giving itself a lot of powers. There's one very interesting provision. This also shows how what the mindset was in making this law. So under the CRPC, public prosecutors were appointed by the central government or the state government as the case may be. I suppose in most cases always the state government, because the central government didn't come in to appoint those prosecutors. In section 18 of the BNSS, it says for every high court, central government or the state government shall, after consultation with the high court, appoint a public prosecutor and may also appoint one or more additional public prosecutors for conducting in any court trial proceedings, etc. To that there's a proviso saying, provided that for the National Capital Territory of Delhi, the central government shall appoint prosecutors, additional public prosecutors. Now, for those of you who follow Delhi, will know that this Delhi state government was appointing prosecutors to deal with it. So they didn't have Delhi police, but the Delhi government had prosecutors. Now, this means that for Delhi, the central government will appoint prosecutors when, of course, the Delhi government has been fighting cases in the Supreme Court on the separation of powers between the central government and state government. I think there's one more case now coming in because you have this being taken away. So why I'm saying this is in terms of is it just a police state, or is it now, are you saying prosecutors are no longer officers of the court? They are also representing the state, which was not the understanding in the CRPC in 1973 when the CRPC came in. I think that's a point of concern on this. And I think very briefly to your other question, I think the answer would be we don't know because why they brought it into offense against the human body, etc. Like you said yourself, there's nothing to say why all of this was done.
basically there are a couple of provisions if you look at it. I was just looking for this. There is a provision under section 172 of the new CRPC, which where they make it mandatory. Let me just see that provision. So this is persons bound to conform to lawful directions of police. Then it says that all persons shall be bound to conform to the lawful directions of the police officer given in fulfillment of any of his duty under this chapter. And if they then it says the police officer may detain or remove any persons resisting, refusing, ignoring, or disregarding to conform to any direction given by him under this section. So I think many of us here are people who have regularly disobeyed, so to speak, the police directions to in a protest, whatever it may be. So it actually gives them that additional power to remove a person, and it makes it mandatory for you to do this, and gives them the power to actually to remove a person, and if they disregard or any of these directions that are given. So one, I think, see, there is excess power that has been given to the police. There has been a level of arbitrariness that has been allowed for, both in the way in which offences have been defined, making it so vague that it allows you to interpret in various ways, and the and apart from that, it also gives these powers to the police to register, not register, whatever it may be. So that's one part of it. The other thing that it actually does is that it does more than just being a police state. So it actually there are several provisions that have been brought in which insulates public servants from any form of accountability. Okay, so if you look at 175 of the law that replaces the CRPC, it makes it the mandate of the magistrate ordering investigation in a complaint against a public servant, subject to receiving a report containing facts and circumstances of the incident from the officer superior to him, and it says after consideration of the assertions made by the public servant as to the situation that led to the incident so alleged. So it gives this additional layer of protection to public servants in terms of actually bringing them to bringing them to the accountability to them. So if we really look at it, in many ways it changes the relationship between the individual and the state. Insofar as it really it takes away your constitutional understandings of whether it's equality, whether it is your fundamental freedoms. So I think that gets very strongly affected. Of course, why it is under that, like Munal said, nobody knows. Nobody knows why any of these provisions really are there, because they have not felt the need to actually explain why they have done what they have done. But I think it is the bringing in of this provision of the Terrorist Act into the law that replaces the Indian Penal Code is something that we have to recognize the extreme draconian nature of. Till now, it was something that was under the UAPA. It was something that required the provisions, whatever minimal safeguards you have under the UAPA, for you to actually bring it. If you allow for this, for a provision like this to be actually put on somebody, it's something that's really very dangerous. I think it was not read out the provision in respect of what replaces sedition, but if we look at the provision that where they have looked at Terrorist Act, I spoke about some part of it. So it says whoever does any act with the intent to threaten or likely to threaten the unity, integrity, sovereignty, security, or economic security of India. Okay, or with the intent. So economic security of India can be anything, right? Or with the intent to strike terror or likely to strike terror in India or in any foreign country by using bombs, dynamites, or other explosive substances or inflammable substance, lethal weapons, etc., or by any other means of whatever nature to cause. So it does not actually even involve you to use weapons to use to cause death of or injury to any person. Like I had previously said, loss of or damage to or destruction of property. So any act which is the intent of, let's say, causing damage to economic security, what they believe, with the which causes damage to property, So loss or damage to destruction of any property, that amounts to a terrorist act. And you don't have those minimal safeguards that you otherwise have. So this is something that has very serious repercussions in terms of how it will be used. Whether it's in why it is put in a particular chapter, notwithstanding, the fact that they have actually introduced this is something that's very dangerous. Just to add one point to what Nal was saying in terms of organized crime, he was mentioning that those are offences that generally look at people from who are from the vulnerable sections, and that's how it's really defined. Someone who's poor. If you look, there is a, for example, Karnataka has a land and land grabbing, anti-land grabbing act, and if you go to that court, and the intent of that law was actually to, or stated intent was to look at large land grabbers, right, where people were actually grabbing. If you go to that court, you will see that the people who are all there are people who are on government land, who are cultivating government land of small, of small measurements, small farmers, so people who are cultivating land. That's who are the people who are attacked. So in fact, this also mentions as part of organized crime. One of the things is land grabbing, if I'm not wrong. So it mentions that. So how does the law work itself in the way in which it uses these provisions? Also allows for something like this to take place.
I think I'll just take the last one question, two questions, one each to both of you, and then we can open up for question and answers from the audience. This is, in the last 10 years, we've also seen an increase of polarization and hatred around us. And in just 30 days after the NDA government came to power this time, you saw 24 instances of mob lynching that were happening across different states, right? And if you look at the new one, there's a provision that's been added to the new IPC, which talks about the question of grievous hurt. So, in your understanding, do you think it will be able to adequately deal with this kind of mob lynching, these kind of hate crimes that are being perpetrated, especially against the Muslim and the Dalit community? And what is your understanding of that? One. And second question is that there are many state governments as of now, like Karnataka had constituted an expert committee which was to look at these laws and how much of these laws would be basically applied here in this state context. We have seen Tamil Nadu and West Bengal have also constituted similar state committees to expert committees to see how much of these laws will be applicable in their state context. And keeping all of this in mind and the ways that the states are also trying to exercise their federal powers when it comes to these criminal laws, what are some of the ways forward that you're both thinking that needs to be done? You talked about some protests that have been happening by the truck drivers and by the other civil society and lawyers groups. What are the other ways forward in which we can imagine to retain some of our fundamental rights and the rights that the jurisprudence of, say, for example, cases like D.K. Basu, Lalita Kumari have given to people like us?
So I think let me just also take, because you said rights given to us, let me just add one more thing. So we had a section 156.3 in the CRPC, which essentially was going back to what we started discussing, that if the police did not file FIR, you could go to a magistrate and there get the magistrate to issue an order to the police to investigate. That essentially was 156.3 was interpreted by the Supreme Court 2008 or 2009 in the case called Sakiri Vasu, which then gave a lot of powers to citizens to do this. What has been done now in the FIR provision is to say that when doing that, you have to have an affidavit, right now, which then adds one more layer of some procedure into that. And it says that the magistrate will then call the police officer, hear the police officer, and then decide as to whether you want to go ahead and order for the investigation. Which then again, going back to that police state question, you're bringing in police into everything where earlier you were not being heard, because I don't see a necessity to hear the police officer as to whether they needed to file the FIR or not. You're not taking action against the police officer, you are instructing them to register the FIR. So to come to this section 103, which is punishment for murder, it says when a group of, this subsection 2 says when a group of 5 or more persons acting in concert commits murder on the ground of race, caste or community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life. It does not obviously say religion, right? It says community or any other, which then you can obviously interpret religion into that as a stable group, but very clearly, because mob lynchings have also been happening in the context of religion, that being left out. But again, we have to see how this ends up getting interpreted. On on the various loopholes, the various problems that we have in the laws, again, I don't know how quickly courts can come back in to reassert, hopefully reassert all the jurisprudence that was built over the years to ensure that that interpretation stays in terms of the changes that have been made. So I think some of this will be in courts quickly enough to see how, including something like this, the FIR, Leta Kumari, Sakiri Vasu, all of these cases, which was a sort of a bundle of rights together, all of them being disintegrated in one way or the other. I think we have to see how that goes forward.
So I think what was read out, what the provision that they say is for mob lynching. I don't think we can have a doubt that the religion has been intentionally left out. Of course, one can argue that it should be, it should come into that, it would come into the broader category that has been, but it's a fact that they have intentionally left it out, and it is in a time where we are seeing lynching, especially against the members of the Muslim community, at such a, I mean, in such a horrible and in such an increasing way. It has been specifically left out. That's something that we have to recognize and we understand this. But of course, one can argue for that it should come in. How, whether the courts will accept it, whether the courts will say that there was a specifically it was left out and therefore we cannot bring it into this. Those are things that we'll have to really wait and see. But I think in terms of where do we go from here? One, like you mentioned this, the Kannada government has set up this committee and they have said that they want to bring in some kind of some changes into the law and remove some of these provisions. In fact, we had a meeting with the law minister from the All India Lawyers Association of Justice and the All India Lawyers Union and the Indian Association of Lawyers, the three lawyer organizations. We had a joint meeting with the minister where we had submitted a memorandum and we have appraised them of some of these changes that we are also looking at. And we hope that those will be considered. We seem to say that some of these things are things that they are looking in that line of. That's of course at the state government level. I think the important thing for us to recognize is that it's really going to affect all of us. It's not. Very often we believe that we have the criminal law at one, and we are not going to get affected by it. Somebody else is going to get affected by it. But I think it's important for us to acknowledge that, like sitting in this meeting can be considered an offense. Making these statements can be considered an offense. So it's really it's something that is going to really hit home to many of us. So it's important for all of us to really come out against it. In terms of immediate things, the to push the state government to bring in these amendments, and I hope we will fight for all of our fundamental rights, not only some of them. So to really push to ensure that whatever the provisions that are unconstitutional, that should not be there. At least at the state government level, they should really consider that. So something, so to put pressure on the government to actually do that. That's something that's very important. And I think it's really not seen the kind of protest that it should have seen. If we really look at it, why didn't they bring this was enacted in December. Why didn't they bring it in before the elections? They didn't bring it in before the elections because the damage might have been that much more serious. You want to keep it ready, and then when you come back, so I think the protests against this have been very insufficient in respect of, if we really look at what is the kind of effect that it's actually going to have. And so it's important for us, I think, to recognize that it's not something that somebody else necessarily needs to be protesting for all of us to come. That's actually the reason that we also brought out this booklet, so that people see that what is the real consequence of these laws and how it is actually going to affect people. So even if we are not talking about being on this side of the law, if you go file, register a complaint, it's something that anyway nobody likes to do. If you go and file a complaint, now you have that much more powers with the police. So unless we have some kind of a stronger opposition to it, I think that I think I think we are allowing something very serious to happen without actually raising our voice against it. If you look at Tamil Nadu, for example, I think there have been a series of protests. I think there have been boycotts of the courts, also boycotts of by the lawyers that have taken place. West Bengal, and the day this law was brought in, they termed it the a Black Day, and they had some protests over there. But I think one is definitely for lawyers. It affects lawyers in so many other ways also, because you have to sit and relearn the whole thing. So so that's something that definitely lawyers will look at. But I think it's important for all of us to also recognize that this is we should not let something like this pass just like that. It's important for us to really put out our voice against it and ensure that and and it's not that I mean the government was forced to withdraw the anti-farmer laws that came in. So it's not something that's necessarily stuck in stone, because some of us just generally believe that it's done and there's nothing really we can do about it. So I think it's necessary for us to really all come together, recognize that it's going to affect all of us, and see how in what way that we can all be part of protests, or in ways in which we can compel the government to really take this back.
Thank you so much, Mrinal and Maitri, for those critical insights and for really giving us something to think about in the ways forward also. That we're really, like Maitri said, we're letting this moment pass in our lifetimes where we're seeing the complete overhaul of our criminal justice system in such a big way, and there is a bigger ask on us for us to be able to protect our fundamental rights. With that, I'll open for questions. If people can just please raise hands and then we can see. I see one hand there. Two. Yeah.
Yeah, so just my questions are on two sections that were discussed here. One was on the land grab thing and another one was on the terror section. So on the land grab thing, I just wanted to understand how it will affect the informal settlements as well, the demolition and the whole drive that is also going on. So how the impact will be on that, and from the terror section perspective, and looking at the industrial relations code where freedom of association is also getting under attack. So how these two laws now play a role within the right to strike, or in general freedom of association. So these two things.
Just one thing, is everybody okay with the question answer being recorded? If there's any objection.
So
Yeah, one more person had their hand there, Janani. Yeah, please.
I was wondering how the new laws deal with digital evidence seizure and how they kind of correspond with rights to privacy, especially in the context of what has recently happened with many civil society groups and people and how media, personal devices and media are being used to sort of prosecute.
So, again, maybe more appropriate for you to take land grabbing, but just to answer how it defines it, like I mentioned, it says any continuing unlawful activity, which then defines as doing a cognizable offense punishable with 3 years or imprisonment or more, which involves land grabbing, is defined as organized crime. Right? So it's a broad way of dealing with this issue. So can the situations you mentioned be brought under land grabbing? The answer would be yes. But again, because it then further defines, it says organized crime, syndicate, continuing unlawful activities. There's so many definitions, all woven into this section. It can be used in whatever way the police want to, but I think it also gives scope for challenging it, because there's so many things here. So I think the other way to look at it, the more positive way to look at it, is because it's defined in so many different ways. There's also a possibility to say, look, it doesn't fall within this. On the digital evidence thing, I'm not paid attention to that, so I might not be able to answer. But I think one thing that I want to mention here is in a lot of places now, wherever it's said that you can record, where video recording was required, and search video record, now it says it can be done on the mobile device of the police officer. right? So it just then takes it to a completely different level, both in terms of it being easily shareable to the media, right? So it can immediately come out within hours of a search being done, whatever they. And I think the sanctity of the evidence, which is what was very important in terms of digital evidence. I think some places they just go by saying you can just video record it on your personal mobile device to the police officer, and at the same time, in the section with respect to investigation, it also says, and I think this everybody has heard about because the Home Minister has also spoken so much about it, is the thing of saying that we'll have forensic evidence in every case. Saying that in every crime scene with imprisonment of 7 years or more, there shall be a forensic examination of the crime scene, assuming that every crime scene will produce forensic evidence, for which we'll have enough forensic scientists to go and look at each crime scene. I think, yeah, a lot of assumptions. And I think very problematic also in both ways, because when we're talking about the gendered effect of this, there's the entire question of sexual violence and the fact that you will not find forensic evidence in most cases, and now insisting on forensic evidence in cases may also lead to a situation where you get more acquittals because you're saying I couldn't find any forensic evidence.
Yes. So,
Yeah.
so this, in terms of the digital evidence, one is data privacy. The other is that in terms of manipulation of digital evidence, there's actually no real safeguard that is put in. So you know what happened with what has happened with Bhima Koregaon, and the way in which this digital evidence has been manipulated, and so we have seen the way in which this can be done, and it's something that I think in many cases that one is seeing this. So I think that those safeguards are really not there. And when you're speaking about digital evidence, if you're not going to ensure something against manipulation, it's going to be how do you ensure the sanctity of that evidence? So I think that, of course, is something that one will have to see what happens. The land grabbing, like I said, it's so vague. It's so vague in which it has been done. And the point is, who does the state finally target? You have all of these offences, but the people who get targeted are not people who are. You have people who have encroached over so many acres of land over here, which with no, you're not. If you see, there'll be no case that is filed against them, but you'll actually have cases filed, like I was mentioning, what has happened in the Karnataka Land Grabbing Prohibition Act. Also, you have cases that are filed against people who are maybe cultivating small pieces of land. And so it leaves open to anything. So because you allowed the police to, and one, you've not defined it to actually exclude something like this, and finally, this is who the police see. When you see a criminal only in the poor, you see criminal only in the. I think the other question that you raised about what happens to the right to strike is something that definitely needs to be looked at, because the industrial relations code that has been brought in actually does not even, I mean, that it increases the penalty for strike. It increases the penalty for so there is a provision on supporting a strike. The word is not supporting, but there's another word that is used where you in any way support a strike. So a strike of workers, people contribute money to that strike. So you contribute money to the strike, also you can be you can be penalized under it, and it goes to over 1 lakh if I'm not wrong, the penalty. And of course at the same time they have reduced penalties for non-payment of wages, non-payment of minimum wages. So the penalties that were imposed on employees have been reduced. But this, of course, will taken together. It is something that will definitely have a effect. And if you look in the Bhima Koregaon case that is there, if you look at the initial arrest that took place, one of the arrests that took place was of contract workers who were working in Reliance, who are working, saying that they have, they were part of this, and they were the ones who were actually protesting against their working conditions and all of that over there. So you look at the way in which the law is also used. It's used very selectively to attack people. So certainly this is something, especially in the way in which it has defined, any destruction of property in any means to damage economic security. These are all terms that can be interpreted in any way to attack workers who may be on strike, who may be on protest. These are things that can definitely be I mean, that interpretation certainly allows for it, and it is no secret that there is a concerted attack on the working class, right? From whether we are looking at these criminal laws and the way in which it is going to come about, and the labor codes, all the codes that are there, that are the way in which it has been framed, to demolish the right to organize, the right to strike, the right to agitate. That is something that's definitely being there's an intent to attack.
Can people raise hands? We have time for 3 more questions. 1, 2, 3. Yeah. One question, everybody. We'll keep it brief. 1, 2, 3.
Madam, under new provision 172, unduly extraordinary powers has been given to the police department. And also with the 90 days detention by the police. Don't you think this is overtaken, overpowered by this act, and Advocates Protection Act has been made dummy? What way, in relation to Advocates Protection Act, under the new provision 172 and 90 days detention, advocates has protection under the Advocates Protection Act? I feel Advocates Protection Act has been made irrelevant, has been made dummy.
My question is more basic in the sense of, especially being a lay person, I keep hearing about Lalita Devi and Vasus. Okay. Can you briefly tell what were the points involved and what Supreme Court gave? And secondly, trade unions and labor organizations have not voiced their protest against this much.
I as a common citizen know that until 20 I have the right to go with a lawyer, or seek the support of a lawyer when I go to a police station, and which when I go to a police station I generally go with a lawyer. No, it's not that I go often. Alright, but there was an instance where I did. Don't you think there is a need, legal aid at a different level we talk about, don't you think we need lawyers at every police station? Wherein we are talking about vulnerable sections, and I work with construction industry, so I know they are vulnerable. They get taken away at 5 o'clock in the morning. But don't they need, the government needs to give them a lawyer at the police station, wherein when they walk into the police station, they go with the lawyer, and because you don't understand the language at all, and when they seek support, they understand the language, and I think a black coat is more powerful, which limits a lot of atrocities by the police. So what do you think? Is that a viable solution?
Yeah, I want to understand in the state committee what they can do legally to make amendment or changes. What powers this state has?
Just to go back to those 2 judgments, so Lalita Kumari was a judgment of the Supreme Court on this, whether there's the police can have a preliminary inquiry before registration of the FIR. In Lalita Kumari, the Supreme Court had said that in every case which makes out, like I said earlier, a cognizable offence, the police are mandated to register a FIR. But they had given a little bit of leeway, saying for 5 offences, essentially, if I remember correctly, medical negligence, offence against women and family, economic offences, offences where the FIR has not been filed for 3 months, etc. In those situations, you can have a preliminary inquiry to find out whether a cognizable offence is made out or not. So it was a very important case which basically said that police are mandated to register FIR. So what I mentioned earlier was that what the law does now is it gives preliminary inquiry in a huge set of cases. So it then sort of dilutes the Lalita Kumari standard, which said you have to register FIR in all cases. The DK Basu case was essentially on the rights of an arrested person to ensure that there's no custodial violence. There are guidelines as to what has to be done, which most of those guidelines are now in the law. So those were the DK Basu guidelines. So on the question,
Trade union and labor.
can you answer? Okay. So on the right to legal aid, I think if you go back to Justice Krishna, sort of the one who interpreted Article 20 in what all you said now, uh, the understanding at that point of time was exactly what you mentioned, that there should be a right to have a lawyer in a police station. And if you look at the Supreme Court's rulings from 1980 up to 2013-14, I think more and more and more that right was, at least on paper, given, saying that you can have someone in the police station. All of that was taken away in Kasab. Right? Because in Ajmal Kasab, if you remember, all of us remember this, he was videographed giving a statement in the hospital where he was asking who did this, who did that, etc. Now, in his trial, the argument was he didn't have a lawyer. Right, so all of these confessions should not be considered because nobody told him he didn't have to do all of this. So unfortunately, in that case, what the Supreme Court said was that lawyers are only in the trial; they're not before the trial, etc. So we have this thing in law where we say hard cases make bad law. So Kasab was a case where I think unfortunately because evidence was there on camera. You didn't have to say that confession was not really required at all. The only thing about that confession was where he was saying the ISI handlers, etc., was what was in that confession. So I think Kasab was a case where the Supreme Court pulled back those rights in a particular way, and then in subsequent cases it's been difficult to get out of what that case said. But in fact, for the nearly 30 odd years, on like I said, in theory, on paper, there was a right if you knew that you could take a lawyer, like you said, with you to a police station. There was nothing. The police couldn't say you can't have your lawyer with you. To the extent that the case law also said that you can have a lawyer with you while you're being interrogated, as long as the lawyer is a little bit far away from you, but not sitting with you, but little bit far away from you, and the person can stop you from answering questions, etc. Because that goes to the right against self-incrimination that we have in Article 20 of the Constitution. So it's been there, but how it's been implemented is a different.
So this your question on what the state government can do. So this powers fall under list 3 of the Constitution, so both the center and state have the power. And the state government has the power to make amendments. And in fact, if you look at the previous code also, in fact, I think UP had made an amendment in respect of anticipatory bail, where they removed the provision where anticipatory bail could be granted. So the government has the power. There are provisions of, there are constitutional principles of repugnancy, which, what would, whether it's repugnant or not, but those are things that will have to, those are things to be kept in mind. But in principle, the state government has the power to make these, to bring about amendments to this. And it's something that has also been done in the past. The question insofar as trade unions are concerned, actually trade unions have come out against this law. The problem is that very few people have actually come out against this law. If we look at it, it should have brought out many more people outside to come out and say that we don't accept these codes. We don't accept these new laws. The way in which they have come, and what they contain is something that we are going to reject. More people should have come out, generally speaking, but they haven't. But given that the working class is so directly hit by it, they have actually come out against this and have demanded for this to be taken back. In fact, even like I mentioned, the first case that was registered was against a street vendor. So that is something that people have also, the unions have also condemned and said that this is something that is unacceptable. But I think the unions have come out against it. But I think it's important that I don't think it has gotten the response that it ought to have gotten. On the Advocates Protection Act, I think that's something that we need to look at a bit more and need to see in what way that what will happen, because the police action that is there is of course against the arbitrary powers that have been given to them are against everybody.
So this is one last question from somebody who was watching online. Her name is Mansi Hatkar. She's basically asking that can we expect a caste-based discriminatory division of labor under the introduced category of community service as punishment? This is like it was observed in the Rajasthan prison labor allocation. So a new provision of community service has been included in the new laws. If one of you can please answer this.
So actually, that's a good thing that the question came because we didn't speak about this
Community
this
service.
community service. And it's a new form of punishment that has been brought in, which is completely vague, which is not defined, and which there are no real guidelines in respect of what community service means. And if we look at the kind of judgments that have been passed in the past, where they have actually, the judges have actually given this kind of so-called community service, which is not a punishment specifically. One of them was to tie a
Wash case.
yeah, exactly. Where he had to write an
Wash case,
imposition.
That was the thing now.
Yeah.
Where he had to
The
write.
difference for him is that he does community
Yeah,
service.
and I think that was he has to write some imposition or something like that.
I see.
The and you had cases where they have been directed to tie Rakhi on the rape survivor. Those are the kind of things that have been said. So certainly this is something that can that's something that can actually happen. And I think there was a report also in respect of the way in which caste-based labor happens in prisons. So why that same kind of mindset might not play itself out even looking at community service, that I don't think there is anything that prevents it from happening. See, what it says in how it looks at community service, section 23 says, community service shall mean the work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. That's the way in which it has been defined. So it is so overbroad, it's so vague that it allows for anything. In fact, there was something that at one point of time, I think there was a direction to donate to the PM fund, PM Cares fund.
Yes.
There was a punishment. So it has been absolutely anything, and given our feudal and casteist mindset that our society has, there is no reason why that something like that may not happen. Of course, it's wrong. Of course, it's something that's impermissible. But this law allows something as vague and overbroad as that.
I just wanted this came to me that so in the Terrorist Act definition, when they look at the economic part of it, economic destabilization also, they'll say if something, for example, like shorting stocks, like what happened with Adani and so on, would it also fall under a Terrorist Act?
Yeah. Economic security.
Well, anything.
But they are not considered terrorists.
There was one, again, going back to community service, because of the fact that in many US states community service was, and the critique was that essentially shoplifting by Hollywood celebrities, you would say, okay, then you have to sweep the outside of the store for the next 1 week. And the critique was exactly this, that look, what do you mean that sweeping is something that's punishment, right? So why are you, so there was the entire angle of sort of looking at labor and saying that there's something wrong with this labor, so it's punishment. And I think when it says without remuneration, there's been this entire thing about, do prisoners have rights to minimum wages? You like say in Tihar jail, you're making soaps and selling it and saying, no, we will not pay you wages because of the fact that this is part of punishment. Right? So it also brings that problematic thing that you're taking sort of, so community service could also be that, yeah, go to the prison factory and make all of these things, and we will not pay you wages, but then we will reap benefit, the state will profit out of that. So I think that's and leaving it undefined obviously just leads to whatever the judge thinks, planting trees, anything can be community service. For whatever offense you have committed, from economic offense, you go plant 100 trees, and that will be your punishment for it.
So I think it's been a very fruitful and engaging session. For those of you, I know many of you have more questions. Maybe the speakers can hang around for a little while and answer if they have time. But we'll officially draw the session to a close. Thank you so much for making time on a weekday evening and coming. And housekeeping rules, we have places to wash our mugs on the left there, and the dustbins are here somewhere. We'll find them and give them to you. And please remember, if any of you has the capacity to donate, please do donate. Thank you so much. And if you have not filled that registration sheet which went around, that's our mailing list. please ask me or Purna for it. We'll pass it on. Yeah. Thank you.
Our booklet is available online, so anyone who is interested, please feel free to
Online.
download it from our
Online. If you look at iLaj and you type this name, it will come. It's only blog. AILAJ.